Court does call the case. People are Clara, is it Ganon versus Holly Ellison?
This courtroom session starts like a routine rent dispute docket, but don't let that fool you. What looks simple on paper quickly turns into a chain reaction of financial chaos, legal loopholes, and emotional breakdowns. Judge Simpson is stepping into a courtroom packed with eviction threats, unpaid balances, disputed repairs, and people fighting to keep roofs over their heads. And right away, one thing becomes clear. Every case has two stories: the landlord's numbers and the tenant's reality. But whose version survives under oath? Watch closely, because in these hearings, tiny details can change everything. Missed paperwork, repair disputes, rental assistance forms, even one payment made at the wrong time can decide whether someone keeps their home or loses it. And trust me, some of these explanations are going to sound reasonable, until the contradictions hit. Question is, if you were the judge, would you go by sympathy or strict law?
Yes, I am the plaintiff, Claire Ganon.
All right.
Holly Ellison.
All right, this is a non-payment of rent case. The summons, I think there was an amended summons that was done on the case. That's what was supposed to happen. We did that on the 19th. I adjourned it to today's date at the 8:30 time to try to get our paperwork in place. All right. Ms. Ganon, how much are you claiming is owed at this time?
$4,545.20.
4,500. You trailed off there at the end.
4,545.20.
All right. And that includes your court costs?
It does not. I did not put that in the paperwork, so I'm not including that.
Okay. It doesn't include court costs, but that's all right. We'll work through that. Ms. Ellison, how are you intending on getting that paid, or do you dispute that amount?
Well, I'm under a MISTA contract where I pay Clara Ghana $50 a month due to the landlord not making repairs. I'm under contract with MISTA till March 31st. I am actively seeking a new place of residence, and they will terminate the lease when I move.
Okay, so if I get the bottom line to that, Mr. saying repairs haven't been made.
The repairs have been made. The repairs have
Pardon?
been made. I have documentation.
Hold on.
That
Ma'am.
Sorry, my bad.
Ms. Allison, what you're indicating to me is that that at least Mr.'s claiming repairs haven't been made. And did they stop payment of their portion?
Yes.
That's what happened. Okay, so that's how you got to how this balance gets to where it is. So, and Ms. Ganon, when the repairs were made, has Mr. contacted you regarding whether or not they intend to pay any back balances?
So these repairs were made back in January. This was actually a long time ago, and her lease has ended, and that's why Mishta is not paying, because the lease has ended.
Sir, may I speak?
Yes, you may.
So with the new MISTA contract that started, was it March, I believe, March 1st, it carried on the before lease. So it's the same lease with Prime Property Management.
Gotcha. Okay. All right, folks, here's what I'm going to do. You're looking for a new place in any event, but there's this back balance here, but this is really a possession case only. I will adjourn this to October 10th, 2025 at 2 p.m. That's an in-person hearing, so everybody will need to be here.
That adjournment is more important than it sounds. A lot of people here come back later and think nothing happened, but legally, This buys both sides time to strengthen their case. The tenant now has a chance to gather MSHDA paperwork and possibly legal aid. The landlord gets time to solidify the debt claim. Judge Simpson is basically saying, I'm not ruling blind. Smart move. And notice this, he frames it as a possession case, not just a money case. That distinction matters. In eviction court, possession of the property is the priority. Money often becomes secondary. If the tenant loses possession, even partial payments may not save them. That's the harsh reality. But here's something to think about. Should courts be more aggressive in forcing landlords to prove repair timelines before even discussing back rent? Or is that the tenant's burden to prove?
Bring your paperwork regarding the MSHDA issue, and then I can maybe at that time take a look at it and try to figure it out. If in the interim, ma'am, you wish to contact legal services, you may do so to be represented by an attorney on this case, all right?
Okay,
All right, thank you, folks.
thank you.
Court does call the case of Blue Heron Point versus Crystal McKinsey.
Yes.
Good morning, Your Honor. Brian Butchart, P 66250. I appear on behalf of the plaintiff.
Yes.
Yes. Ms. McKinsey?
Yes.
All righty, thank you. What is plaintiff's claim in this case?
Your Honor, this was filed as a non-payment of rent claim for possession only. The rent to retain possession pursuant to my client's records is currently $2,257.99. We're seeking court costs in the amount of $170 for a total of $2,427.99.
And ma'am, how are you intending on getting this paid?
I was gonna ask the court for more time. Unfortunately, my employer has been bouncing my checks, and then they just mailed them all out on Friday. So I was gonna ask the court if they can give me more time to pay them.
Now this is brutal. Imagine being behind on rent because your own paycheck bounced. That's not irresponsibility. That's instability on top of instability. But here's the legal reality. The landlord usually doesn't absorb that risk. Whether your employer pays you or not, rent is still due. Judge Simpson knows that, but he's offering something valuable here: time. A 1-week adjournment might not sound like much, but in eviction court, a week can mean survival. Notice how he also warns her October rent will be added. That's huge. This debt snowballs fast. Miss 1 month, and suddenly you're fighting 2. This is where many tenants collapse financially. Audience question: if your boss bounced your check and it put you at risk of eviction, would you sue the employer? Because that chain reaction right there can destroy someone's entire housing stability.
Well, what I can do is I can adjourn this out a week. During that week, if you're seeking assistance, you would have to file the requisite forms or the necessary forms that came in your packet. That being the rental assistance form, file that with the court within or by Wednesday.
Okay.
And if you're seeking legal assistance, you'd have to do it within that time frame. So I will adjourn this matter out. Regrettably, I do not, counsel, have next week. Is that right? It's the 10th is my next available date. So, and ma'am, you're, just so that you're aware, at that time, plaintiff's claim is going to include your October rent.
Yes, sir.
We'll adjourn it to October 10th, 2025 at 2 p.m. If it is all not paid, ma'am, that is an in-person hearing, so you will need to appear at the courthouse.
Yes, sir.
All right. Thank you.
Thank you, Your Honor. You and your staff have a good
Thank
day.
you, sir. You do the same.
Thanks.
HP Foreclosure Solutions versus Jeffrey Bogdan and Deborah Bogdan.
Good morning, Your Honor. Adam Devlin, P72877 for the plaintiff.
All right. Your name, ma'am?
Mary Cheatham.
Okay, you're gonna have to speak up or up for all of this.
I'm sorry. Mary Cheatham.
Okay. And ma'am, what is your relationship to this case?
I am the daughter of Jeffrey and Deborah Bogdan. They are both deceased, Your Honor.
Okay. All righty. And this is a termination. The basis for the termination is a foreclosure.
Yes, Your Honor. Failure to inspect.
There was actually an inspection done on August 11th by Michelle, who works at HP Foreclosures. And I understand that it was late. I don't know. It's really a long story. My mother passed away in January. There's just been like a series of unfortunate events. And I actually have a probate hearing on Monday at 1:30.
This just turned from a foreclosure case into a life crisis. Probate, incarceration, parental death, all colliding at once. Legally, though, the court can't simply stop because someone's life is falling apart. That's one of the coldest truths about civil court. Judge Simpson hears the humanity, but jurisdiction still matters. Then comes the bombshell. The plaintiff's attorney realizes an inspection may have already happened. If true, that could completely undercut their standing. That's why he says, subject matter jurisdiction. Translation, the court may not even have authority to continue this specific claim. That's massive. One overlooked inspection could collapse the whole case. And that's why documentation is king. Here's the irony. In the middle of all this tragedy, the strongest weapon may be paperwork. Would you have pushed for dismissal right there, or waited for verification like the attorney did?
Where I'm hoping, because I was appointed as the executor in her will, and I'm hoping to get that appointment letter. I just really am asking for like the full redemption period. I was incarcerated. I was just recently released. My mother passed while I was incarcerated. I'm just trying to get all this stuff figured out. I realize my time is dwindling down. I'm just asking for the time that I'm allotted for the redemption period in order to do that.
Your Honor,
Okay,
if
go
we've
ahead.
inspected, I lose subject matter jurisdiction to be here. My client did not inform
Right.
me that they inspected. It asked to be thrown in a breakout room with her and have the pretrial adjourned 2 weeks with the understanding that I'm probably going to dismiss.
Okay. I typically don't do breakout rooms, but under these circumstances, I
just
may
need to get
make
her
an
contact
exception.
information, Your Honor.
All right. So, ma'am,
Yes,
here's
sir.
what I'm going to do is I'm going to adjourn this out to October 10th, 2025
Okay.
at 2 p.m. Okay,
Okay.
that's an in-person hearing, ma'am.
Okay.
But what it sounds like, so that, I mean, seems to me you got a lot going on. You've indicated that there was an inspection, so
Correct.
that may, I'll put it this way, potentially divest the court of jurisdiction to hear the matter, depending on the timing of things and whatever and the like.
Okay.
So I think what counsel wants to do is he wants me to put you into a breakout room so we can get contact information so we can check out what you've said.
Okay.
Okay, do you have any problem with that?
No, sir.
All right, fantastic. Then
All right.
what I will do is I'll adjourn it to the 10th at 2, I think I said. At 2 p.m. That's an in-person hearing, and I'll put you two into a breakout room. All
Okay.
right, thank you. Thank
Thank
you,
you.
folks. Arbor Manor Townhomes versus Diana Allen.
Thank you and good morning, Your Honor. Paul Huth, P31986, appearing on behalf of the plaintiff.
Diana Allen?
I believe she's in the Zoom room. I see the name.
Hi, I'm here. I'm just trying to turn on my camera. I'm sorry.
All right, while you do that, Mr. Hughes, what is your claim?
Thank you, Your Honor. This is a non-payment possession only case. The amount of rent due is $3,402, court cost of $172, for a total amount due of $3,574. The last payment
All right,
in this case was back in March.
gotcha.
Current rent is
All right,
$69.
okay, thank you, sir. And ma'am, how are you intending on getting that paid?
I applied for SCR. I have been approved. I have a phone interview on Monday. I can also put a payment down about $700-800 on Tuesday.
This is one of the most practical courtroom moments so far. STR, short-term rental assistance, can be a lifesaver, but Judge Simpson immediately spots the issue. The numbers don't fully cover the debt. She owes over $3,500, but the maximum assistance for her household may only be $740. That gap is deadly. This is what traps so many tenants. They qualify for help, but not enough help. And watch the judge here. He's doing math in real time while making sure she understands the reality. That's effective judging. No false hope, no sugarcoating, just facts. And this is where financial literacy becomes part of survival. Because if you don't understand what aid actually covers, you can walk into court thinking you're saved when you're still thousands short. Would you risk waiting on assistance or scramble to borrow the rest immediately?
And a couple more hundred on Friday as well. So I'm hoping that they can help me with majority of it. Um,
Are you
but
talking SER?
Yep, and I sent the office my application as well.
All right. So there's a couple things going on here. You need to pay the 700 or 800 or what you can pay. All right.
Okay.
And what I'm going to indicate, you're going to get that, the 7, 8 plus maybe a couple hundred, and that you're going to do that by the 3rd
Yes.
of October.
Yes.
Okay. If you apply for an SER, you'll also need in your packet, there was a rental assistance form.
Yep.
You'll need to fill that.
I filled that out as well.
Okay. Have you submitted it to the court?
Yes.
I don't have it. Make sure that it is submitted to the court. Actually, I think it's here.
Yeah.
Okay, I've received a rental assistance form, it looks like.
Okay.
However, I don't have you're gonna need to redo it because you have to put the tracking number on it of your SER.
Okay. I can do that.
And the other thing is, how many people are in your household?
It is me, and then I have 3 other children.
Okay, so you have a total of 4. Just so
Yes.
that you know, the maximum you're gonna get under an SER is $740, and that's typically gonna have to be paid before they're gonna pay. So just so
Okay.
you know, they're not going to cover the amounts here. All right.
Okay.
With all of that, I'll adjourn it to my next date of October 10th, 2025
Your Honor,
at 1 p.m.
Judge,
Yes, Mr.
I have a conflict on that date. I didn't think it was going to go 2 weeks out. Could we do the 24th? That's my,
I have that right.
Yes.
Okay, I'll adjourn it to October 24th, 2025 time at 2 p.m.
thank you, Judge.
Ma'am, you're
Yes.
welcome. Ma'am, that is an in-person hearing, so you'll need to appear at the courthouse.
Okay. Thank you, Your Honor.
Thank you. Arbor Manor versus Sharia Patillo.
Thank you. Good morning, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff.
Hello.
Hello. All right, what is plaintiff's claim?
This is a non-payment possession only case. The amount of rent due is $2,224.06, $172 in court costs. Total amount due $2,396.06.
All right. Ma'am, how are you intending on getting that paid?
My grandfather is gonna give me the money. I just have to wait until he gets paid because I lost my job due to having seizures and the medicine that I was put on. I can't work. So he was gonna be financially responsible for me as far as to pay off.
All right. When is he intending on doing that? Do you know?
He told me that he needed about 2 weeks. I don't really know if it's possible to get that.
All right. So what I'm going to do is I'm going to indicate that you're going to pay the balance. I'm presuming and your October rent by the
Yes,
10th.
sir. Yes, sir.
All right. And given Mr. Hughes' schedule, I'll adjourn this out to October 24th, 2025 at 2 p.m.
Thank you, Judge.
Okay.
All right. If you
Thank
get
you.
everything paid, ma'am, if you get everything paid, then it's likely they're going to dismiss this. But
Okay.
everything needs to be paid. You got to make sure everything is paid. Otherwise, you got to be here at the courthouse.
Okay.
All right. Thank you.
Thank you. Have a blessed one.
You do the same. Arbor Manor versus Felice Wilson.
Good morning, Paul Hughes, P31986, appearing on behalf of the plaintiff.
All right. Miss Wilson is here present in the courthouse. Okay. So you can stand right up at the podium, ma'am. See that there?
I have something for you.
Hold on. What's your name?
My name is Felice Wilson. Good morning.
All right, thank you. What are you trying to give me?
This was a printout statement of the payments that I made and the misunderstanding of them going up on my rent and why I have a balance. So I got the printout from the bank and from them.
From the bank?
And from them, the ledger. It's just a 12-month ledger from both parties. It was my rent been on time forever. And there was a jump in $500 and they kept telling me that they would change the rent. And I was waiting for them to reply. So it was just.
Was that a recertification issue?
I gave you that because that's the only thing I had when I came to write the letter. I gave you a copy of the recertification and they said I would be due in March. They reprobated, I guess, my rent and gave me up until March to pay off whatever I owe.
Stop for a moment.
I'm sorry.
What is plaintiff's claim in this case?
Thank you, Your Honor. The amount of rent due is $3,075, $172 in court costs, for a total amount due of $3,247. It looks like her current rent is $422, and that's down from $825 in June.
Okay. First of all, do you agree that your rent is $422?
As of now, yes, sir.
As of now?
Yes, sir.
All right. And you're basically indicating that you have paperwork that you made all of the payments. So how much are you paying per month?
I'm sorry. So I do pay the $422. My rent was $170 every month and I would pay $200. In April, they recertified me. She said it would go up to $325. And then I started getting stuff on my door saying it was $825. When I went to tell her, I can't afford that. It doesn't equal out 30% of my income. She kept telling me she would change it. Wait till we contact you. And every week I would get, it was just adding up and they never changed it. So I would pay what I could. And in June, when the court put the paper on my door, I just stayed at the office until someone talked to me. They sat there and they adjusted it to the $422.
Pause right there. This might be one of the strongest tenant defenses we've heard all day. A jump from $170 to $825 is massive, and if that came from a recertification or subsidy recalculation error, this could become a serious accounting dispute. Judge Simpson immediately starts narrowing the facts. Current rent, prior payments, ledger consistency. That's because this isn't just non-payment anymore. It may be misapplied charges. Big difference. If management gave conflicting rent amounts, that confusion could weaken their claim. But there's another side. If the tenant kept underpaying without written confirmation, that can still accumulate legally. This is exactly why paper trails matter. Receipts, notices, rent recalculations, everything. This might be the most complex case yet. Who do you think dropped the ball here? The tenant for trusting verbal promises, or management for not correcting the ledger?
I asked if they were going to readjust what the proper payment would be for my reassignment. And she said that you have to pay the $2,000 off. I just feel as though from $170 for a year and a half.
I hear you.
So I just got the statement. You can see that I paid on time.
Are you going to have an attorney represent you on this, or are you going to represent?
I've never been in this kind of situation. I just don't want an eviction. It's scaring me and I'm trying to fix what's going on. I trusted that the office told me not to worry about it.
Ma'am.
So,
you have the right to have an attorney. Okay. You can contact legal services regarding that. Okay. If that is something that you'd like to file with the court, you may, but you'll have to send a copy to the plaintiff's attorney. Okay. All right, if that's the ledger. So you can file that certainly at the counter with the court and do that, and we can deal with that. Okay. I'm going to suggest that you contact legal services, and we can make sure that you have the phone number to do that. I'm going to adjourn this out, given the court schedule, Mr. Hughes' schedule. I'll adjourn it to October 24th, 2025 at 2 p.m. Okay. And go ahead. What were you going to say?
I just had a question. So I am paying what they asked for as of now. I've been paying extra to pay down. Do I continue to do that for next month? I'd
certainly continue to pay it. The worst that could happen is that you'll ultimately end up with a credit if that amount wasn't due. I mean, that's the worst thing that's going to happen to you. Okay. But if the money is deemed to be owed, then at least you chipped away at what the amount would be.
I understand.
Okay?
Yeah.
All right. Thank you.
And certainly go talk to your landlord and go over it with them and they'll explain exactly what the issue.
All right. Ma'am, Mr. Hughes was saying, go also to the rental office, explain your circumstance again, and have them go over the ledger with you so that everybody can maybe be clear by the time we get here on the 24th.
No problem.
All right. Thank you.
Thank you, Judge. Have a good weekend.
You do the same, Mr. Hughes. Court does call the case of Sile Farms versus Holly Cornelli or Connolly today.
Good morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
Right. Are they here?
No.
They have not checked in. If you'd like to take a default, you may raise your right hand. Hello. What's your name, ma'am?
Holly Conley.
Okay, she's here. We've got you. Okay. What is plaintiff's claim in this case?
Your Honor, I have rent to retain of $2,287.06, court costs of $190.00, for a total of $2,477.06.
And ma'am, how are you intending on getting that paid?
My ex-husband is supposed to cut a check, and we're in the process of hopefully transferring this over into our children's name.
That phrase, supposed to, is one of the most dangerous phrases in eviction court, because legally, supposed to means absolutely nothing until the money clears. Judge Simpson handles this perfectly. He doesn't dismiss her explanation, but he doesn't rely on it either. That's why he adjourns instead of ruling. Smart. The whole case is now hanging on someone who isn't even in court. That's risky. And emotionally, you can hear it. She's juggling disability, family transfer issues, and financial dependency. But the court only tracks one thing: payment. This is one of those moments where sympathy and legal obligation collide head-on. And honestly, depending on an ex-spouse for emergency rent might be one of the weakest safety nets imaginable. Audience question: would you trust a verbal promise from an ex when your housing is on the line?
I have recently lost
I'm
my-
sorry. You've got to stay right near your microphone because you're moving in and out. Say that again to me.
My ex-husband is supposed to be paying for it. We talked to him last week and he said he could do it. The problem is he's in Washington, and so his hours are funky and it's hard to get a hold of him. But he said he'd pay it because we're in the process of transferring this over to my children because I'm going on disability. We can't afford it anymore because the rent goes up every year. And so we're going to see if we can't transfer it over to my children.
All right.
The process of all that, but as far as being able
So
to get the
he's
whole
gonna. So your understanding is he's gonna pay the entire balance, but you're not
Yes.
sure when that's gonna happen.
He's supposed to pay the entire balance within like the next 10 days. But
Okay.
and then he's going to buy the trailer from me and I'm going to leave and we're going to turn everything over to my kids and go to
Gotcha. Okay.
the
So here's
sign
what I'm
over.
gonna do. Here's what I'm gonna do in terms of the payment. I'm going to adjourn this matter out to my next available date, which is October 10th, 2025 at 3 p.m. That's an in-person hearing. If what you're indicating is correct, and I don't have a reason to doubt it, he should have paid everything off by that point in time.
Yes, he should have. Yep. And then he's going to pay
Okay.
that as well. So October will be covered too.
Okay.
Okay.
So very good. Then we'll do that. That's an in-person hearing. So if everything is not paid, you need to come down to the courthouse.
All right. And if everything's paid, then we're good to go.
Pardon?
If everything's paid, then the court's canceled and we can go ahead and sell the trailer over to my kids and have my kids fill out the paperwork for the hearing, right? In other words, if he pays, I don't come to court, right?
Pay that at the court?
If he pays the whole entire bill, I don't come to court. Correct?
You do not have to come to court if everything is paid off.
Got it. Thank you.
Thank you.
Thank you, Your Honor. I just would also like to state that to Miss Holly to stay in contact with your landlord regarding any transfer of home ownership or leases.
Okay. Yeah, I was gonna
Okay.
call him. Once we get a hold of my husband again, we'll we'll start contacting you, starting the process of transferring over.
All right, thank you.
Thank you, Your
Silo
Honor.
Farms versus Lauren Eccles.
Casey Matson, P87729 on behalf of plaintiff.
She's here for prompting.
Ms. Eccles?
Yes.
Okay, she's here. What is plaintiff's claim?
Your Honor, I have rent to retain of $704.33, court costs of $190.00, for a total of $894.33.
All right, Ms. Eccles, how are you intending on getting that paid?
I can pay it on the 1st.
Okay, you'll pay it on the 1st?
Mm-hmm.
Okay, you're out. Are you going to pay October also?
Yes.
Okay, so you're going to pay the whole balance on the 1st?
Yes.
All right. I will then, she's entitled to it, so I'll adjourn this out to my next available date of October 10th, 2025 at 3 p.m. Ma'am, that is an in-person hearing. If everything is not paid, you'll need to appear at the courthouse on that date.
Okay. Thank you.
Thank you. Sile Farms versus Craig Gallagher.
Casey Matson, P87729 on behalf of plaintiff. Your Honor,
Go ahead.
Your Honor, this case is actually, they're paid in full, so we would ask that this case be dismissed.
And just like that, case dismissed. This is the cleanest possible ending in eviction court. But what's interesting here is timing. Notice how often people wait until the absolute last second to pay. That tells you something about pressure. For many tenants, court isn't just punishment. It's the trigger that forces action. The moment legal deadlines hit, money suddenly appears. Sometimes borrowed, sometimes scraped together, sometimes pure luck. But here's the key legal takeaway. Dismissed without prejudice means it's over for now, but future issues can still come back. It's not a free pass. And for landlords, this is often the ideal outcome. They get paid without dragging through trial. It's the rare win-win in this docket. But be honest, do you think some tenants only pay because they know eviction is finally real?
All right, very good. Thank you. Case is dismissed on plaintiff's motion without prejudice. Sile Farms versus Tyler Kroll.
Casey Matson, P87729 on behalf of plaintiff.
He's here for prompting.
Kroll?
I'm here.
Okay. All right. Your name, sir?
Afro.
Okay. Thank you for turning on your camera. For whatever reason, your Wi-Fi may be weak. So we're going to shut down your video, okay?
Sorry about that.
No, it's okay.
Yep.
We'll just shut down your video so we can hear you. I've seen you already now. I can hear you. So let's shut it down. All right. Counsel, what is plaintiff's claim in this case?
Your Honor, this is also paid in full. We would ask
Okay.
dismissed without prejudice.
All right. Mr. Kroll,
Yes, sir.
you paid everything?
Yes, sir.
All right. Well, it was great seeing you. You have a great weekend. This case is going to be dismissed.
Thank you. Have a blessed weekend.
All right. You too, sir.
Bye-bye.
All right. Court does call the case of Sile Farms versus Jason Rhodes.
Casey Matson, P87729 on behalf of plaintiff.
He's up there. Mr. Rhodes? Is he stationary? Okay. Are you stationary, sir? Because you're in a vehicle. He is. Okay.
Yeah.
All right. What is plaintiff's claim in this case?
Your Honor, I have rent to retain of $2,102.28, cost of $190 for a total of $2,292.28.
All right. And sir, how were you intending on getting that paid?
I have a $2,000 cashier's check I was going to drop off yesterday, but the office closed.
Okay.
This is one of those frustrating near-miss cases. He's close, very close, but not fully there. Judge Simpson's strategy here is practical. Lock in the large payment now, reduce the debt immediately, and buy time for the rest. That protects both sides. But notice what the judge refuses, rolling the balance into future rent. That's a critical line. Courts don't like stacking old debt into new obligations because it muddies enforcement. Clean numbers matter. Jason's broken ankle explanation also matters emotionally, but again, not legally enough to erase debt. That's the pattern today. Hardship explains the delay, but it doesn't erase liability. The judge gives him a roadmap. Now it's on him. And here's the question. If someone shows up with 90% of what they owe, should that be enough to stop eviction automatically?
All right, so you have the 2,000 and then the 292.20 and some change. Let me put it that way. When are you going to get that paid?
Could we put it on October's rent payment?
Okay, I can't agree to do that. If you get everything paid before the end of the month, they'll dismiss the case.
Okay.
So do you think you can do that?
I just got back to work. I've only been working for 3 weeks. I was out with a broken ankle for a month and a half. So that's why we're running behind.
Can't do it, you can't do it. But here's what I'll do. Get the $2,000 paid to them today. Okay?
Okay.
And then if you can get that balance in before the 30th, that would be great. But if not, then we'll deal with it in October. I'll adjourn this to October 10th, 2025 at 3 p.m. Okay, that's an in-person hearing. And at that
Okay.
hearing, October rent will also be included in what's due. You understand that, sir?
Yes.
All right, very good. And we'll see you then, or maybe not if you get it all paid.
All right. Thank you.
Scio Farms versus Amanda Ridley.
Casey Matson for the plaintiff.
It's Ridley?
Yes.
Okay, gotcha. She's here. All right, what is plaintiff's claim?
Your Honor, we have rent to retain of $1,192.08, cost of $190, for a total of $1,382.08.
All right, Mr. Ridley, when are you intending on getting that paid?
As soon as we get off the Zoom call, I have to go put money on my card and I'm going to pay it online.
Okay, so you're gonna pay that today, the whole balance.
Yes.
Okay, then what I'll do is I'll indicate that in my file that you're gonna pay that today. I will adjourn it out in case something goes wrong. Let's hope not. To October 10th, 2025 at 3 p.m. If everything's paid, they're gonna dismiss and you don't need to appear on that day.
Okay.
All right. Thank you. Court does call the case of Scio Farms versus Jesse. Is it Steinberg?
Yes, sir. Jesse Steenberg.
All right, she's here. All right, and also there's a Brent Steinberg. What is
My
plaintiff's
husband.
claim?
Your Honor, I have rent to retain of $2,964.67, cost of $230, for a total of $3,194.67.
All right. And ma'am,
Mm-hmm.
how are you intending on getting that paid?
Hi. I can pay it. I can pay it on the 10th of October. My husband, our primary income, it works a lot off of commission, and he gets paid monthly, so it will be paid on the 10th. Does that amount reflect the 2,000 that I just made a payment of by chance?
Here's a kitty.
When did you pay the 2,000?
Last week?
Let's see.
It does reflect that $2,000 payment, Your Honor.
Okay, it does. So this is the balance that was given is what you owe as of today.
Okay.
Okay. So you think that you're gonna have the whole balance? What about October rent, ma'am?
October rent will be paid before the end of October, for sure.
Okay.
This is the debt spiral in real time. She's trying to solve September while October is already approaching. That's the treadmill. And Judge Simpson breaks it down clearly. If the current balance isn't cleared before month end, the next month stacks on top. This is how manageable debt becomes impossible debt. Notice her confusion about whether she still has to appear if she pays part of it. That tells you how overwhelming this process can be. Courts operate on precise deadlines, but real life doesn't. Commission-based income makes everything unpredictable. That's why the judge urges early payment, not because he's being nice, but because accounting timing matters. One day late can completely change legal posture. Question for viewers: should courts build more flexibility for commission workers? Or is rent still rent no matter how income arrives?
So you're going to pay approximately $3,000 by the 10th. Is that right?
Yes, sir.
All right. So that needs to be paid as early in the day as possible. And if you can pay it on the 9th, it would be greatly appreciated so that we have a proper accounting. I will adjourn this out to October 10th, 2025 at 3 p.m. Ma'am, that is an in-person hearing, so you'll need to appear at the courthouse regarding this case, okay?
Okay, even if I am able to pay off, but because I didn't pay off October yet, I'll still need to appear. Is that right?
Correct. And you're
Okay.
not paying the balance that is currently due before the end of this month.
Okay.
You follow me? If you paid it off before September 30th, then they dismiss the case and you would need to come. But that
Okay.
doesn't sound like that's what's happening. You're going to be paying that on the 10th because of the way you guys get paid.
Yes, sir. I
So
understand.
then we'll be dealing with October. Okay?
Okay. Thank you.
All right. Thank you. Scio Farms versus Arkeem Kirk. And LaFlora Jackson.
Casey Matson for the plaintiff.
Kirk and Jackson. There's no response. If you'd like to take a vote, you may raise your right hand to be sworn.
Your Honor, they actually did pay a significant amount. There is a small $40 balance remaining, so we would request that this case be dismissed without prejudice and that the $40 balance be preserved.
All right. Case is dismissed on plaintiff's motion without prejudice, reserving the $40 balance that's due. Thank you.
Thank you, Your Honor.
Scio Farms versus Alex Corser.
Casey Matson for the plaintiff.
All right. Alex Corser, Alyssa Proctor. They're not here. I've been trying to swear you in all morning, but okay. Is this going to be one that we're doing? Okay.
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
All right. Go ahead.
Thank you, Your Honor. We're requesting entry of a default possession-only judgment. Rent to retain is $2,024.81. Cost of $230 for a total of $2,254.81 with a writ to issue after October 6th.
Judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. Scio Farms versus Carol Chanel.
Casey Matson for the plaintiff.
Carol Chanel, Michael Kelly. Neither are here. And neither are here. You may proceed.
Thank you, Your Honor. There is a small balance remaining in this one. However, we would request a judgment. There's
Go ahead.
rent to retain of $26, court costs of $230 for a total of $256.00 with a writ to issue after October 3rd.
All right. Judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. No writ without a hearing.
Thank you, Your Honor.
All right. Thank you.
And that wraps a brutal day in Judge Simpson's courtroom. One packed with unpaid rent, broken promises, disputed ledgers, probate complications, and last-minute payments. The biggest pattern? Most of these cases never came down to bad people. They came down to timing, paperwork, and financial gaps. Judge Simpson stayed consistent. Verify the numbers. Offer lawful time when possible, but protect possession rights first. That's the foundation of housing court. Some tenants bought themselves time. Some cleared their debt. Others weren't even there. And in court, absence can be fatal. Default judgments moved fast. And that's a reminder, if you ignore court, the court won't ignore you. The broader lesson here is simple. Communicate early, document everything, and never assume verbal promises protect you legally. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.